Thank you for joining me this afternoon, well, morning if you're on Central Time. Again, my name is Jordan Walker. I'm with the law firm of Sever Walker Padgitt. We are eminent domain attorneys. Today, as you're probably aware, we are going to be talking about eminent domain and some utility projects in the state of Tennessee. We'll get into exactly what we're going to discuss here in a bit, but we're going to be talking about the projects a little bit. We're going to be talking about eminent domain quite a bit, and we're going to be talking about how to handle these cases. And with that being said, we're just going to go ahead and jump in. Oh, and I should say, if you have questions, feel free to ask them in the box to the right. There's also a Q&A box. I might not address them until the end of the presentation, but please don't hesitate to ask those questions. Again, this webinar is presented by Sever Walker Padgitt Law Firm in conjunction with Tennessee attorney Chris Owens. Again, my name is Jordan Walker of Sever Walker Padgitt. I am a partner at that firm, and let's jump in. Real quick, a little more background so you know who you're talking to in our law firm. Our law firm, Sever Walker Padgitt, we are eminent domain attorneys only. This is the only area of law that we do. Not only is it the only, not only do we only do eminent domain, but we only do landowner cases for on eminent domain matters. So we only do eminent domain and we only work for landowners. We have never worked for a condemner, whether it's a DOT, whether it's a utility, a pipeline, a power line. We've never done it. We've only represented landowners. And as a consequence, because of our very specific area of practice, we've learned quite a bit. And we've handled these types of cases quite a bit as well. We've handled hundreds of pipeline cases, hundreds of power line cases. Honestly, you name it, we've handled it. We also do quite a bit of road work, but we're not here to talk about road projects. We've done this a lot. We've done this in Tennessee. We've done it in Georgia. We've done it in Indiana, Illinois, Iowa, Oregon, Kentucky, Missouri, you name it. We have represented landowners across the country on these types of acquisitions. And as a consequence of that experience, we have learned quite a bit about how these projects work, how these companies operate, and obviously eminent domain law across the country in various states. So we've learned a lot, and over our years of doing this is the only type of law that I've practiced. And because we've learned so much, we have this knowledge that we can then provide to you and let you know what we've learned, share our experience with you. And that's our goal today. And that's what we'd like to do, is share our experience, let you know how these things work. On these projects specifically, I understand that they've been going on for a little while. So in a lot of times, the landowners become kind of de facto experts on how these things work because they're dealing with these right-of-way agents so much. But nonetheless, there's maybe something that you missed or that you don't know. So we're going to talk about what we know. So the projects that I referenced earlier, so this mailing that we sent, we actually sent mailings to 3 different projects: the Ridgeline expansion, which is a pipeline, the Sullivan to South Bristol project, that's a power line, a transmission line, and then the Cumberland expansion project, that is also a pipeline. And I'll just, and the reason why we mailed to multiple projects is that the issues are, from power line to pipeline, are broadly similar, if not identical. And we'll talk to that point here in a bit, but it's important to remember that whether it's a power line or a pipeline, yes, there are differences, and we'll get into that, but you are largely dealing with the same issues across both types of projects. So we mailed to multiple projects because the issues overlap quite a bit. So the Ridgeline expansion and the Cumberland project, those are both natural gas pipelines. Ridgeline is an Enbridge project in conjunction with TVA. And the Cumberland project is a Tennessee gas project, which I believe is a subsidiary of Kinder Morgan, which is a large energy company. Obviously, they all are. The Ridgeline expansion and Cumberland project, they are natural gas pipelines, like I said, and because they are natural gas pipelines, and because these companies have sought FERC approval for these projects, as natural gas pipelines generally are, it is governed by FERC. FERC is the Federal Energy Regulatory Commission. A lot of you guys might already be very familiar with what FERC is and what FERC does. I understand that on at least Ridgeline, there has been quite a bit of discussion about the FERC process. I'm very familiar with FERC. We went through something similar on the Spire pipeline, which is in Missouri and Illinois. On a lot of these projects, especially recently, there's been a lot of discussion about how FERC does their reviews and their siting for these pipelines. I'm not going to get into that today because we are not FERC attorneys. We are eminent domain attorneys. So to the extent we're going to be talking about what's going on at FERC with these pipelines, we are not, because that is not our area of expertise. We are going to talk about the acquisition of your property and the use of eminent domain. Like I said, I do understand that several of these projects maybe are being challenged to some extent by various parties, which is fairly common. And I don't want anything in this presentation to be construed as our firm supporting or rejecting supports to challenge these pipelines. To the extent landowners want to challenge pipelines or interest groups want to challenge pipelines, I love seeing it. It's great to see folks volunteer in the process, get their voices heard. And nothing in this presentation should be construed to diminish those efforts, because we're not doing that. We're just talking about what happens if those efforts fail and ultimately they need to acquire your land. What then? Well, we're going to talk about that and how to protect yourself even if these projects get approved. If they don't get approved, fantastic. You just learned quite a bit about something that you don't need to worry about. So in any event, the Ridgeline and Cumberland project are governed by FERC, and they received the certificate of public convenience and necessity from FERC, which they then use to initiate federal eminent domain lawsuits. So the way it works with these natural gas pipelines, they go to FERC, they get approval. Once they get approval, they use that approval, they take it back to the state where they need to acquire land. They go to the federal court, and very likely they will go to the federal court. And in wherever the federal footprint your property is located in, they'll file a condemnation lawsuit at federal court. And we'll talk about what that means here in a bit. But it's important to remember that Cumberland and Ridgeline are governed by a federal eminent domain process, whereas Sullivan to South Bristol, which is a transmission line, a TVA project, another TVA project, I should say. Because it's a transmission line, there's no FERC involvement. It's governed by state law and state eminent domain process. So I just want to clear up, these are really the biggest differences between the two projects. So I've already mentioned it, eminent domain. What is it and who can use it? So eminent domain is the forced seizure of private land to put to a public use. This is inherent in our government, inherent in our constitutional history. It is in the Constitution, or the power of eminent domain is applied in the Constitution through the Fifth Amendment. For a very long time, this eminent domain was restricted to public entities, or strictly public entities like DOTs, states, municipalities, so on and so forth. That is not the case anymore, and private entities or semi-private entities like utility companies, energy companies, are able to condemn property if they're putting it to a public use. And the public use in this instance, power lines, pipelines, et cetera, even though they are private companies, because they're utility projects, they are public uses. So this allows them, with the proper authority, to take private land, even though they themselves are private companies. That is how it works. So for all projects, the eminent domain, this is the eminent domain process for any project in Tennessee, whether it's Ridgeline, Cumberland, or South Bristol. For any project, you will receive an offer of compensation. I'm sure that several of you already have received these offers of compensation. It's a pre-condemnation offer. This is statutory for state law, and it's common law for federal process as well. So in any event, they have to give you an offer before they file any sort of condemnation. I'm sure several of you already have offers, so you know what that looks like. So for any eminent domain process, the seizure of private land for a public use, they'll offer a pre-condemnation offer. They will generally negotiate, especially pipelines and power lines. They generally do negotiate, although not very well if you're not an attorney sometimes. So they make the offer. They will engage in some bit of negotiation. Eventually, though, they will need the land, and they can't rely on landowners to come to an agreement with them. So eventually, if it gets to this point, and they need the land, the landowner has now relinquished it, they will file a condemnation lawsuit against the landowner. So the landowner, if they can't reach a deal with the utility company, will be sued by the utility company. If it's a pipeline, it's going to be in federal court, very likely. It could potentially, theoretically, go through state court. Energy companies generally avoid state law if they can. So it's likely that they'll use federal procedure, federal court. And for the transmission lines in Tennessee, it's state court using state law in the county where the property is located. So the forum, I should say, if it's a pipeline, you'll be at federal court. If it's the transmission line, you will be at the local state county court where the property is located. So that's that is a difference between the two, but again, it's the same thing. And when you get to condemnation, there are really two things that are up for debate, and one of them really isn't up for debate. There's the first discussion in eminent domain, whether the taker, the condemner, the utility, has the right to take your land. And generally, it is very difficult to challenge whether or not they have the right to do it, especially because they are a utility project, or they are a utility company building a utility project. Those are de facto public use, so it's very difficult to argue that. Really, the only argument you likely will have to challenge the authority of a utility company to take your property, the only argument you're going to have is if they didn't follow procedure. And the federal procedure is pretty light, so they usually meet that burden. And the state procedure is a little bit pre-condemnation procedures, carries with it a few more requirements, but still, that would be the only challenge you'd have. And ultimately, even if you win on that challenge, they can always refile. So I'm not going to say that you shouldn't challenge a taking, but if you do plan on doing that, I would talk to an attorney about your arguments, because it's important to remember that it's got to be based on the law, and the law for challenging these types of projects is not great. So after that was the first component, challenging the authority of the pipeline or power line to take at condemnation. You're probably not going to do that, or you will likely be unsuccessful if you do. So what's the next part? The next part is money. So I should say the opposite of the challenging the authority is arguing for more money. The playing field is a little more level between the landowner and the utility company when you're talking about money, because the landowner is entitled to just compensation, and that too is in the United States Constitution and the Tennessee State Constitution. You are entitled to just compensation for the acquisition of your property under threat of eminent domain. And we'll get into what just compensation means, but it's important to note, because you're entitled to that, it isn't up to the pipeline or power line to tell you what your property is worth or tell you what you're going to get. Ultimately, what that means is that you can present your evidence to somebody else, either a jury, a judge, or a commission, and they get to determine what your just compensation is. That is the end of eminent domain. After they've filed their lawsuit, at the end, that's if not a settlement, if a settlement hasn't been reached, I should say, at the very end, you have the option to present your evidence for just compensation, again, to a jury, judge, or a commission. And I'll touch in my next bullet point is what type of trier of fact will you have? What type of audience will you have for this evidence of your just compensation? At trial, federal pipelines under federal eminent domain law and procedure, there is no guarantee to a jury trial. You do not have a guarantee to a jury trial, and it is unlikely that you will get one for a pipeline condemnation. What is more likely to happen is your case will be heard before a judge, or a commission, or a assigned judge, basically a commissioner, an individual commissioner. That is federal law. That's how it's generally handled. So I would not expect a jury trial at federal court. On the other hand, for transmission lines, you do have guarantee of a jury trial. you have the right to a jury trial if you request it for transmission lines in the state of Tennessee. So what that means is that if you get all the way down to the end of the process and you're still involved, you haven't settled, you will present your evidence to a jury, just like the transmission line will as well, and they will determine ultimately what you get. So that is the 10,000-foot view of eminent domain. That's how it works. It's really just important to understand that they sue you, and that ultimately you have the option to present evidence to a jury, a commission, or a judge. And the reason why I bring that up, and we'll get into this as well in the next slide, is that you're going to hear a lot of things from right-of-way agents prior to condemnation. You're going to hear a lot about condemnation from them. Usually it's going to be used to scare you or to intimidate you. Eminent domain, the terms to a layperson, people that aren't familiar with it, is somewhat of a scary term, especially when it's told to you by a right-of-way agent. It's used to scare landowners into taking what's offered to them or taking less or this or that. And a lot of times they will say, I've heard a lot of things from right-of-way agents that have been told to my landowners, my clients. I've been told that if you go to eminent domain, you'll get nothing. If you go to eminent domain, you'll get less, or it's a guarantee you'll get less. If all of these, they'll just take it. It's not how it works. There are protections built in, but at the same side of that coin, the other side of that coin is that if what I tell folks with utility cases, and each case is different, but generally what I tell folks with utility cases is that if you are in eminent domain, meaning you haven't reached a deal, they filed the lawsuit, you're arguing with attorneys for the utility company. If you are at that stage of the process, you've waited that long, you still haven't reached a deal, it's because you should want to be there. Eminent domain is not a venue. It's not a venue. It's not a process I would get into voluntarily unless the case should be there. And a case that should be there is one where there's a lot more money than is at stake than what they're offering, and that they haven't offered it, they're not showing a willingness to, and that it's worth the investment to get that outcome. So in other words, getting into eminent domain extends the process, it makes it longer, and it might necessitate investment from the landowner in the form of appraising and costs that are associated with that. So it's important to keep that in consideration when you're entering eminent domain with the utility company. Another important part of this is that utility companies are more than happy to pay their attorneys to badger you at eminent domain, and do what they need to do to ensure that they get the land for as cheap as possible. And so all that money that they maybe would have given you before condemnation, that pot of money that we can't know what it is, they're just going to shift that to their attorneys, and then their attorneys are going to, who are very highly paid, are going to be very diligent in acquiring your land and going through the eminent domain process. So again, if you're at eminent domain, it should be because you want to. It's not a scenario where, oh, I just got sued, I'll just resolve it at this point. Your case might not be the one that should be at eminent domain. Your case might be one that should have settled prior to. So, and I can tell you about that. I can tell you whether it's a case that should go or shouldn't. And we approach cases, of course, accordingly. So with all that being said, I want to talk a little bit more about pre-condemnation negotiation in consideration of what I just said. What to do when you receive your offer. I know that several of you have already received offers, I'm sure. So this might be a little tardy for your purposes, but it's informative nonetheless. So for any projects, pipelines, power lines, what do you do when you receive an offer? First, what I tell folks, insist that the right-of-way agent communicates via email only. The fewer in-person and verbal discussions you have with the right-of-way agent, the better off you're going to be. And we'll get into exactly why that is, but it's just important to keep everything on the record so that if they make offers or they talk about things that they will do or promise to do, that it's in writing and not said to you in a side conversation when they met you at your property. Verbal promises aren't worth anything in this discussion. They aren't worth the paper they're written on, as the saying goes. So it's important to keep all of the communications with right-of-way agents via email. Once you get the offer, what I tell people is to tell the right-of-way agent via email again, thank you, I will review this and get back to you in a week. You can also do this via text as well. Email is a little more formal, a little easier to read, of course, but as long as it's on the record, we're good. That's what I tell people to say. No one's going to get mad at you for taking a week to decide what you want to do. You could probably even take 2 weeks. But this is an easy response that you can send to them. Gives you a little bit of time to decide what you want to do, but you're also not putting them off either, which it isn't something that it isn't gonna destroy your case, but in any event, this is a good response. So in that week, after you've informed them that you're going to contact or you're going to do your due diligence or review it, you contact an attorney to review it. And our firm, we provide case reviews, offer reviews for free. So if you have an offer and you want me to look at it, I'm happy to do that for free and give you my thoughts. So in this, back to the dealing with the right-of-way negotiations, once you receive the offer, tell them we'll get back to you, contact an attorney, have the attorney look at it, go from there. Again, avoid in-person discussions, avoid in-person negotiations, because there's going to be all sorts of things that are possibly being said that we've heard right-of-way agents tell landowners that it's not great, and it's better to keep everything on the record above board. So we talked about what to do when you receive an offer, what not to do when you receive an offer, and this applies for all projects. Don't just start negotiating. Don't start discussing value. Don't just jump into it. I understand it's instinctual. Someone gives you an offer, you're going to counter. The reality is that you don't quite know what that number should be, and you can't be expected to know because you're talking about complicated property valuation considerations, and you're also talking about eminent domain, which brings in this whole other aspect that you're likely not to be familiar with. So the first thing folks want to do is start talking value. The problem with that is that if they come in and offer you $20,000 and your immediate response is, oh, well, I'm going to ask for 40, and you get 30, and you think to yourself, wow, got a great deal. What if in that scenario you were actually entitled to $60,000, $70,000, $80,000? And even if you didn't ultimately reach a deal with them in this scenario, you're informing them of what your bottom dollar is before you even really know what your bottom dollar is. And the thing with right-of-way agents is that they keep copious notes. They take notes of conversations. They obviously, emails, those exist. You don't need notes, but any conversations are written down, drafted. They stay with your file forever. And so whether you're negotiating pre-suit or you're dealing with eminent domain, they know that your bottom dollar was $40,000. So it's important not to go out and start making claims. That's how landowners get in trouble. What I tell people is that doubling a terrible offer doesn't make it a good offer, it just makes it a bad offer or a less terrible offer. So, and that's important to keep that in mind when you're negotiating with these folks, is you're negotiating on their terms a lot of times, which you don't want to do. Do not enlist an appraiser. A lot of people also will think, well, they have an appraisal that said it's worth X. I need to get one that says it's worth Y. You don't. You might need an appraisal. I'm not. Sometimes these cases require appraisals. What my motto is, what I tell my clients, and how I generally handle cases, I don't get appraisals unless they're absolutely necessary. And in my view, they're not absolutely necessary until you're in litigation, until you're at court. And this serves two functions. One, a lot of times we are able to negotiate on behalf of landowners to get to deals that without the need for an appraisal. So why expend money on something that you don't otherwise need? So that's one component. Two, not every appraisal is the same. The type of appraisal you'd be looking for would be an eminent domain appraisal for a utility project. Very few appraisers can do that type of work competently. This is not like going to a bank or a tax appraisal and having them just value the property, because they're doing, it's actually three appraisals in one. There's the before value of the property, there's the value of the acquisition that they're taking, the easement, and then there's the after value of the property. So they're actually doing three. So it's a complex appraisal that not a lot of people can do, and also consequently costs a lot of money. So we're talking $3,000, $4,000, $5,000 for these types of appraisals if you want it to be good. you can always spend $300 or $400 to get an appraisal, but it's not, again, not going to be worth the paper it's written on. So it's important to remember that you don't need to go out and spend this money. I don't like to spend my clients' money, and that is a big cost outlay that might not be necessary. So I don't advise folks to do it unless it's necessary. Do not meet in person. We already talked about that. Do not take right-of-way agents' promises at face value. Folks, I have heard so many stories about what right-of-way agents tell you. We'll get into what they do here in a bit. Just remember, the goal of the right-of-way agent is to get your land, not to do you any favors, not to help you out, not to properly compensate you. Their duty is to get your land, and they get paid based on how many parcels they lock up. So again, do not, and that goes to my next point, do not assume the utility has your interest at heart, because they don't. Their interest is building a pipeline, building a power line as cheaply from A to B as possible so they can start making money off that project, whether it's the pipeline or the transmission line. That's how it works. Those are their goals. Their goals are not ensuring your land is properly remediated or that you're properly compensated. Their goal is to build this project. Finally, on what not to do not make a rushed decision, but also don't ignore it together. There's kind of two ends of the spectrum. A lot of folks that accept the first offer and move on, that's very likely a bad decision. And at the other end of the spectrum, I have folks that ignore it, pretend it doesn't exist. It sits on the table for months, for years, and then all of a sudden they end up in eminent domain because they never addressed it, and they tried to let that sleeping dog lie. And so I would not follow that path either. So it's important to not rush into a decision, but it's also important not to ignore it altogether. The happy medium is contacting the attorney as soon as you get an offer and figuring out a plan from there. So let's talk about what they want from you. And this is the first key to your case, I'll say, and it's the easement. And for those of you that have offers, you've seen it, you know what it looks like, you know what an easement is. For folks that don't know what an easement is effectively a deed, but it's a deed you're not selling the whole property and the right to use the entire property. You're selling the right to do what the easement says, where and when the easement permits. So it's basically a deed, but for a very specific use in a very specific area, or at least it should be. One question I get a lot is, will the pipeline be permitted to do this? Or will the power line be permitted to do that on the easement? Will they be able to add pipelines? Will they be able to run fiber optic cable? Will they have, full access? Will they have to notify me when they're on the property? All of these things. There's an endless number of things that they can and can't do. And my answer to that every single time is it all depends on what the easement says. The easement governs the rights of the utility company. And because it's a grant of rights from you to them, they can only do what you specifically grant them the right to do. And what that means is that the easement becomes incredibly important. And I've seen this bear out dozens of times where old easements become modern easements. And those old easements were so poorly drafted that when they come back around to add another pipeline, there's no need to get a new easement. And I'll tell you what that means. But the point to remember is that this easement's going to be on the property forever. Once you sign it, it'll be recorded. It'll go with your title. When you sell it, when your kids inherit it, or whoever gets land, they're going to take the land subject to that easement and whatever that easement says. And I'll give you an example of how this, first we'll get into some pitfalls, and then we'll give you an example of how this can go sideways. Some pitfalls we've seen with easement language as proposed by utility companies. These are common issues. I have not seen the easements for these projects yet, but I would suspect that there's going to be a lot of the familiar hallmarks of bad easement on this that I've seen otherwise. If they don't, great. But if they do, I want you to be aware of it. One thing we see a lot is unfettered access. And what I mean by that is that the easement will allow basically full access to the entirety of the property. This is one thing that happens quite a bit. they'll tell you we're only going to use the road to access the pipeline, or we're only going to use the easement itself to access the pipeline, or we'll only use this access road or whatever. But what the easement will actually say is they can access it from wherever they want and whenever they want. They don't need to notify you. This is something that we've seen quite a bit. Unfettered access is a big deal, and it's one that we would negotiate out of the contract. And that, again, access the entire parcel. It's the same thing. There we've seen situation where there's no clauses for future damages or crop losses or timber losses or timber damages, where it doesn't matter what we do in the future, we're not responsible. I've seen that. I've seen a big one is no clause for proper ground restoration, especially for agricultural properties where the soil is so important. I've seen situations where the ground is torn up during construction and not put back together properly. This is a big issue on a lot of pipelines, is proper remediation. And it's very, very important that your easement sets forth in it exactly that what they need to do when they restore the ground. They need to segregate the soil if this is agricultural property. They need to ensure that the topsoil is a certain depth. They need to ensure the pipeline is at a certain depth. These are all construction processes. They won't build in inclement weather or incredibly wet weather. This is an issue that needs to be added to an easement. These are all things that if you don't make them do it through the easement language, they will absolutely try to get away with because it's cheaper for them to do so, cheaper and easier. Liability on sometimes we've seen clauses that where the landowner becomes liable for the acts of the power line on the easement, or they're not indemnified from any act on the easement, where the landowner could get roped into a liability that's not their fault. One huge one, absolutely huge one that we see almost on every easement is the right to build more power lines, the right to sell their rights to pipelines if it's a power line, solar farms. So what they do in these easements, what we've seen is that they say, well, we're only coming in, we're only building a pipeline. But if you read it, it says the right to construct one pipeline, the right to add to the number of the pipelines, the right to widen, enlarge the pipeline. Another, if it's a pipeline easement, they'll have the right to build a power line on it. If it's a power line easement, they'll try to get the right to build a pipeline, because the more rights they get in these easements, the more valuable they can then sell those rights to these other companies that will want to use the easement that they have. So this is something that happens a lot. They'll get the right to do this, even though they say that's not what they need. The landowner doesn't read it. And then what happens 5 years later, another pipeline comes in and they say, we already got the right to do this through this easement. We already a fiber optic cable company comes in laying cable. And that was in the easement. That is something that gets added to the easement quite a bit, or that pipelines try to put in, power lines try to put in. And they're not going to pay anything because you already sold that right to the utility company, which then subleased that right to a communications company. This is what happens. This is how it works. So it's just imperative that the easement's properly drafted. And the final note that I'll end on with easements is that easements are forever. Again, an example of how this comes back to bite people, years down the road, is an example I often use, and that is the Southern Access Pipeline in Illinois. It's a project we worked on several years ago. And what was happening on that project is that a Enbridge, actually it was an Enbridge line, came in and started acquiring land. But what had happened is they weren't really offering a lot for landowners. They weren't even offering new easements a lot of times. Why? Because they owned easement rights that were signed in the 40s by the Sinclair Oil Company, which went out of business. The easement transferred, ends up in Enbridge's hands. They want to build another pipeline, and they go in and they start doing it on the old easement, because the old easement covered the entirety of the property and allowed whoever held the easement to add as many pipelines as they like without any further compensation to the landowner, because they already sold it. So old easements become new easements, and with that, all of the terrible language that was agreed to by your grandfather, your grandfather's dad, what have you, back in the 40s or 50s, become modern and become your issue, or whoever owns the property. That's just an example of how important it is that this easement language is drafted accordingly. So And folks, I'm almost to the end. I'm running a little bit over time. I apologize. The first aspect we talked about was easement language. The second aspect I want to talk about is money, just compensation. And this is what we believe a complete compensation package should include. And this is general, of course. There's assorted issues on each parcel. Every property is different with its own issues. It should include a proper price per acre for the land to be acquired. It should include a proper payment for crop damages up to 5 years, possibly more. And that proper payment for timber damage should also be included as well. Either payment for anticipated soil and ground damages or a clause in the easement that requires the company to remediate properly. A proper consideration of all damages, field tile, irrigation, compaction, soil mixing, debris, flooding, all of these things. They need to be either paid for or they need to be properly enshrined in the easement that allows for recovery later should they occur. And then this is in addition to any bonus payments that are issued by the utility, which we found are fairly common. I want to talk about this one component right here, residual damage. This is a big one, and this is one that is not often brought up by utility companies. Residual damage, I'll put it briefly, is basically the impact that the utility has on the rest of the parcel. So let's say you own a 40-acre tract. It is previously unencumbered with an easement or utility line or anything of the sort, and Enbridge comes in and they want to run the pipeline right through the middle of the property. Well, there's obviously the normal considerations of compensation. That's the value of the land that they're acquiring. But there's also, what does that mean for the 40-acre tract, not just the acre or so that they need right through the middle of it? How does that bisection of the property impact the value of the property? And if it does, which depending on the parcel and in our view it does, then you deserve compensation for the impact on the rest of the parcel. An easy example is that, pipelines, there's a lot of discussion about what pipelines, how safe they are, and whether or not they're going to catch on fire, or explode, or flood, or whatever. It's a common discussion for landowners, it's common discussion at FERC, but the reality is that, and that's something that, it's something that a lot of landowners bring up, but the question is, how does that risk impact the value of the property? And it's our view that it is a risk. Now, whether or not it is a realistic risk or a likely risk, it doesn't matter. How does the market for this property, these types of properties, view that risk? And as we have found out, as we argue, the market, if they're going to buy your property that's encumbered with one of these pipelines or power lines, they're going to need to pay less because the property, in our view, is worth less because it has this huge utility project going right through the middle of it. That impact on the entirety of the 40 acres, it should be compensable. You should receive compensation for any impact your property received, the entirety of the parcel receives, because of the introduction of a power pipeline. And we have several studies to demonstrate that this devaluation of the entirety of the parcel exists. Depending on who you ask, it can be up to 20% of the value of the property. And depending on the nature of the acquisition. And that's a more case-by-case discussion, but it's important to remember that that is something you are entitled to, and it's also something that utility companies don't often offer. Okay, and I am definitely running over. I'm going to run through this a little quicker. These are right-of-way agent tricks, or I guess strategies or things we've seen from right-of-way agents. We've seen offers of 125 to 150% fair market value. Again, this is something to make it seem like they're offering something in your favor. They're looking out for you. They have your interest. They're going to offer you more than what the land's worth. That's an easy way to get somebody hooked into believing that they're on your side. But it's in the eye of the beholder. 150% of a terrible price per acre doesn't mean much. We've seen bonus payments. Again, bonus payments are offered to get quick decisions and say, again, look, we're doing you a favor. These are kind of a guise to prevent the landowner from doing further due diligence into what they're entitled to. Crop damages, again, this is something they've offered. Guess what? If they destroy your crops or impact your crops, they're liable regardless. So them offering crop damages to accept, or timber damages to accept, to the extent that it impacts those crops or timber, that's something they would have to pay anyway. They're not doing you a favor. And ultimately, what they do is kind of a shell game, in that they want you to have these discussions on price per acre, crop, or timber damages, because the more you're having that discussion, the more you're not having the remainder damage discussion, which is what is where the real money and where the numbers start to escalate quite a bit. Remember, they don't have the right to be on your property, not yet. That is leverage, and you have leverage, and leverage equals money. Your ability to keep them off your land is leverage in and of itself. I've seen offers, verbal offers that are issued, and they're issued verbally and then they disappear. I've seen radio agents write numbers down on pieces of paper, take them with them. You know, these verbal numbers mean nothing. This is why I insist email discussion instead. I've seen, oh, if you don't take this, we're going to do this. If you don't take this, we're going to increase it, or we're going to lower it, or this or that. It's all done to keep you in the lurch, keep you guessing. Ultimately, if you're not sure if it's a good deal or a good offer, all you have to do is send me a copy of it, and I will look at it for free and give you my thoughts. So I guess the point of this slide is just to keep in mind that the right-of agents are not looking out for you. They are looking out for themselves. They get paid by how many parcels they get, and they are trying to get your land. And we are to the attorney portion of the process. This is just a real quick description and demonstration of how our firm gets paid if you are interested in hiring our firm, which you, of course, don't have to do if you don't want to. Our firm operates on a contingency fee, which allows landowners to hire us without coming out of pocket. An example of our standard contingency fee is you get a $10,000 offer. You hire our firm, we get you 50. And in this scenario, we added $40,000 to the case. We get a third of the 40, you get the remaining money. So in that situation, you end up with almost $37,000, more than 3 times the original offer. You do not need to pay me to hire me. If you want to hire me, it's as simple as us sending you a contract and you signing it and us getting started. The money comes out at the end. You don't write the checks. We do. We do it this way twofold. It allows landowners to hire us without coming out of pocket. Nobody wants to spend money on an attorney out of pocket. So this allows us to represent you, and the money comes out at the end. Our fee comes out at the end, and it's nice and easy. It also is an implied, I guess, promise to you that we're working on your behalf, because we're also working on our own behalf at this point, because we're effectively partners in the acquisition. So that's why we do it that way, and it's been pretty effective for both parties. Next steps, and this is the last slide, folks. I do see there's a question, so I will answer that once I'm done here. As soon as you hire an attorney, or excuse me, as soon as you receive an offer, you should hire an attorney. At the very least, you should contact an attorney and get a free case review. Until you get an offer, the good news is that you're ahead of the curve. Until you get that offer, begin vetting your attorney options and start forming a plan of how you're going to approach this. Identify what you want done. How do you want the easement written? How do you want? What are your money thoughts? This, and what's important to you. If you can get a group together, if you have a group, that's very helpful for both me and the landowner, because the more landowners that I represent, the more leverage I have against these companies, and it's also good for the landowner, just inherently to be part of a group. We found it's good to have that peace of mind. It's not necessary, of course, and we represent individual landowners, and we always do. But if you have a group and it comes to me, not only is it easier for me to do my job and increases your leverage, but it also allows me to potentially lower my fees, because it allows me to more effectively and efficiently represent landowners if they're all part of one group that's in the same area. And with that, I will end this presentation. I will take questions, of course. If you have an offer, please do not hesitate to send it to me. That's my email address, jordan@landownerattorneys.com. And there's a you can also text it to 470-869-1383. You can also fax if you use fax, 317-575-9943. Okay. That's it. I'm sorry. I'm 15 minutes over. And I apologize for that, but it looks like most people stuck around. So thanks for sticking around. I'm going to answer these questions. Here's the first question. Does whether a landowner have intervened in the FERC docket affect the outcome of an eminent domain case? It should have no bearing on your eminent domain case. Interveners are fairly common, as we've seen and witnessed on FERC dockets before. They happen quite a bit, or there are quite a few interveners. Ultimately, has no bearing on the value of your property or what you're entitled to, and it shouldn't have an effect on your case. Second question: does your firm work on contingency fee? There we go. We do. Where the percentage fees based on the amount recovered over and above the initial offer. Do you require any payment upfront for landowners? We do not require payment upfront for landowners to be our clients. And yes, we operate on a contingency fee basis. Our contingency fee is 1/3 over and above the offer. Okay. Okay, so I answered that question. Are there any other questions? Great question. Does the contingency fee arrangement include litigation expenses? So what I'll say is that there are very few litigation expenses because you are not filing the lawsuit. Because the power line or the pipeline files it, they are responsible for the filing fees associated with that. There might be a small fee to respond to the lawsuit, but it's generally de minimis, under $100. We would cover that. The only cost that the landowner would ultimately be responsible for litigation costs, but those costs are costs that go to other people. And I guess the way to rephrase this is basically, if you're in eminent domain and you have a trial set, you're going to need to get, when I talked about getting appraisals, that's when you get the appraisal, because you need evidence. You can't, you need a third party expert to come in and testify on your behalf. Appraisers do that. They aren't necessary pre-condemnation, in my view. Once you get in litigation, you get closer to trial, you're going to need evidence. You're going to have to pay for those. That would be an example of a litigation expense that the landowner would bear if it got to that point. Again, this is at the end of the process. You're all the way down the line. But so that would be an example of an expense. Other expenses, you're talking about deposition recorders. They are, probably per day about $1,000. The depositions aren't significant depositions. I would say that, and this is an incredibly ballpark figure, if you're in litigation and you go from A to Z, from complaint to jury trial, you're probably looking at, I would guess, around under $10,000 or 5 to 10 in costs and expenses. It's not cheap, of course, but again, if you're spending that money, this is why it's important to know whether you should or shouldn't be there. If I'm telling you that you should be in eminent domain, it's because we're spending that 5 or 10 to get 100 or 200 or 300 or some significant amount of money that makes the investment worth it. If your case is another $20,000 or $30,000, again, it's not a case where I'd say let's go to court. So that's an example of the risk that you're undertaking, and I believe answers your question about cost. Those are the costs you're looking at. You're looking at appraisers. You're looking at and associated deposition costs and court reporters, basically, and your I should say your expert's time for testifying, which is additional as well. Next question. But it would be up to the landowner whether they want to go to trial, right? They could choose to avoid these costs and settle. 100%. It can't be stressed enough that this is your case. I'm here to advise and counsel you. That's my job, is to tell you what I think you should do based on my experience. But ultimately, this is your case. You decide if you want to accept an offer. You decide if you want to settle. You decide if you want to keep going. This is your ship. You're driving it, but I'm advising you how to drive it. So yeah, you can, if you want to avoid these costs, absolutely, you can settle and do it. And I would tell you that if I see this as a scenario where it's not worth, the juice isn't worth the squeeze, I'll tell you that, because it doesn't help me to extend the case, to spend money to get to a spot that we might already be at anyway. So, and I'll tell you that. Other questions? Okay. Well, you guys were easy. Okay, well, thank you so much for stopping by. We appreciate it. I know I went over. I do apologize for that. This webinar should be available via recording later. If you missed anything, I'm happy to send it to you if you don't receive it. If you think of a question that you didn't answer or ask, please don't hesitate to email me. Again, I'm going to share my screen again so you have my contact. Do not hesitate to send me an email, shoot me a text. I do not bill for these things. You're not going to get a bill from our firm. I'll just answer your question, and that'll be that. You can text it, call, whatever works for you guys. So, okay, well, it's been a pleasure. Thank you all for stopping by. Feel free to contact and send in your offers. Otherwise, good luck and have a great day.